And now we continue on with Roman numeral 5, which is all about the U.S. Supreme Court. Starting at the top with selecting justices. Remember that there are 9 U.S. Supreme Court justices, and they are on there for life until they quit or, die, which is pretty much the definition of being on the court for life. They are selected by the president whenever there's an opening. So whenever there's a vacancy, again, because of either someone retiring or someone dying, the president is able to pick the justice, and then they have to be confirmed by Congress. So what exactly does the president look for when he's picking Supreme Court justices? Well, if you look at your outline, I've given you 6 things you should probably think about. The first one being merit. Merit is sort of the duh kind of thing. The idea of merit is that being a Supreme Court justice is the highest honor a lawyer or judge could have. So what the president's looking for is somebody who has earned it. Somebody who has been a judge or a lawyer for such a long time and has earned such wonderful credentials that they would be a wonderful justice. So you're looking for the idea of somebody who has such a wonderful legal background, has worked for this so long, so hard, that they've earned it and therefore get the reward of being a Supreme Court justice. The second one, ideology. While in theory merit is the only thing that should really matter, in practicality it doesn't work that way. Like everything else involving the government, there is politics at play here, and ideology is connected to this. You've got 2 major ideologies. You've got constructionalism and interpretivism. Constructionalism is also known as strict interpretation. The idea of someone who believes in constructionalism is they can only do what the Constitution specifically says they can do. Whereas interpretivism means that they are opening the Constitution up to interpretation. They're interpreting it how they think it should be. Constructionalism, as you might guess, based on that description, is a conservative philosophy, so more Republicans pick that one. So a constructionalist would be the one more likely to say that, the word abortion is not in the Constitution, therefore it's not allowed. Whereas an interpretivist might say, even though the word internet is not in the Constitution, free speech still exists on the internet. Those are extreme examples, but that's the general idea. The constructionalist, again, tends to stick very closely to the actual text of the Constitution, whereas interpretivists tend to be a bit more loose with their definitions and so forth. Again, constructionalist tends to be Republican, conservative. Interpretivist tends to be liberal, Democrat. So, depending on which party the president belongs to and what ideology they have personally, that tends to be the ideology of the person that they nominate. So, for example, President Obama's Supreme Court nominees, Sotomayor and the other one whose name escapes me, generally believed in interpretivism, whereas Bush's ones like Roberts and Alito are very, very conservative, so they're very constructionalist. The third one, the idea of is a reward or loyalty. Sometimes presidents pick justices out of loyalty to the party or loyalty to an individual. The idea being that you are putting someone on the court because they have worked for you very long and hard, and you think that they will do what you want. So you're trying to hand-pick your justice to do exactly what you want. This is sort of a no-no because, again, the Supreme Court is supposed to be the highest law in the land, independent of the President and Congress. So if you're picking somebody just so they'll be your lapdog, it's considered to be sort of gauche. Take, for example, the idea of court packing. Court packing was Franklin Roosevelt's idea. That's right, Will. We mentioned Franklin Roosevelt twice in this chapter, I believe. Court packing is the idea of when Franklin Roosevelt was tired of the New Deal constantly getting overruled by Congress, or by the Supreme Court, rather. He proposed an idea where he would add 6 more justices to the Supreme Court. He would make the Supreme Court 15 people. That means he could pick 6 new justices, which would be enough to put 6 people who are loyal to him and keep the New Deal on the board. Now, despite FDR's popularity, everybody saw through this plan. Nobody was willing to go through with it because they said essentially, you're nuts, you're trying to become a dictator. And so FDR had to back down from court packing. But it actually served its purpose because once he threatened the court packing idea, the Supreme Court generally stopped overruling on the New Deal and basically just let FDR alone. So, threats can work occasionally. But otherwise, reward and loyalty can be part of the calculus, but if it's the only reason you're picking a justice, it's probably not going to end up working very well. The third thing or the fourth thing rather you might consider is representation and public opinion. So what exactly does the public want? What do you want a justice to be for the general public? The idea here is that many people believe that the Supreme Court should be an accurate representation of the public at large, which means that for a very long time you have to deal with the fact that the Supreme Court was mostly old white guys. The first female justice isn't until the 1980s. The first African American isn't until the 1960s. Now we have several women, a Hispanic, and actually that's about it in terms of, well, and I still have an African American member. So it's not the most diverse thing in the world, but nowadays when the presidents are picking justices, they're trying to make it more diverse to better accurately represent the American population. So as a result, when, say, Ruth Bader Ginsburg retires or passes away, she will likely be replaced by another woman because otherwise you would knock the numbers around too badly. Likewise, public opinion, what does the public want? Does the public want somebody who is representative of them? Do they want a more conservative, more liberal? So sometimes the president takes public opinion into account. But remember, the public has no direct effect on the Supreme Court. They don't get to vote for the Supreme Court. They don't get to vote them out of office or anything like that. So as a result, they have a very loose control. So it's up to the president to listen to them if he wants to, or ignore them if he chooses to. The fifth one, the legacy. Now this one is kind of tricky. Remember, again, Supreme Court justices are on there for life, which means they outlast the president by a good distance. So the president has to be very, very careful because no matter who he picks, it will affect his personal legacy. If you're the guy who picked the Supreme Court justice who turned out to be a corrupt lunatic, it's going to look badly on your history, reflect badly on your presidency and your legacy. On the other hand, if you picked one of the wisest Supreme Court justices in history, everyone will give your presidency a lot more credit. So legacy is essentially how is it going to affect people in the future? How is it going to look for your future, your legacy, and so forth? This is why, for example, they talk about how even people who might not like Hillary Clinton, the Democrats who might not like Hillary Clinton, still might support her just so they make sure the Democrats can pick a Supreme Court justice. Because the fear is if you let the Republicans win, they pick Supreme Court justice, they could influence the Supreme Court for decades to come, and vice versa. The Republicans, even if you don't like the nominee, whoever that might end up being, they will probably rally behind him out of fear that the Democrats could appoint Supreme Court justices and create a different legacy. The final step, the sixth thing the president has to consider is confirmation. Can they pass the Senate? Generally speaking, confirmation is a little bit of a rubber stamp. It is incredibly rare for the Senate to knock down a Supreme Court nominee, but that's because the president chooses somebody who's not going to get knocked down, if that makes sense. So it's sort of a chicken and the egg question. Are they perfect because, the president picked them that way, or does the president pick them because they're perfect, etc., etc.? There have only been a couple of examples in recent history where the justice has had a really difficult time in confirmation. Take, for example, Robert Bork. Bork was a nominee suggested by Reagan. Bork got in trouble because of his incredibly conservative philosophy, to the point where he argued that against some really sort of, black letter law kind of things. His incredibly conservative philosophy scared away even some Republicans to the point that Bork withdrew his nomination because he knew he wasn't going to get through. Clarence Thomas was another example. Clarence Thomas was accused of sexual harassment during his confirmation hearings. A woman who worked with him in his previous job claimed that she had been sexually harassed by him, and even though he did get confirmed, it was the closest Supreme Court confirmation in history. The third one, Harriet Miers. Miers was President George W. Bush's personal attorney, and he nominated her to be a Supreme Court justice. But the problem was, she was nominated pretty much only for reward/loyalty, because again, she was his personal attorney. Even the Republicans point out she didn't have a lot of experience. She had never been a judge. And so, when confirmation looked like it was going to get rocky, even with a Republican majority, she withdrew her own name because she didn't want the embarrassment of being voted down in the Senate. So, again, usually confirmation is a bit of a rubber stamp, but you have to be careful that you don't pick somebody who's so offensive that even your own party can't back them up. Now then, so once you've got justices on the Supreme Court, how do they hear cases? Because the Supreme Court hears a very small percentage of the cases that are appealed to it. They only want to hear cases that have to do with the Constitution and are quote-unquote big issues. When you appeal to the Supreme Court, you're asking for what's called a writ of certiorari. The writ of certiorari, or just writ of cert, is the formal request by the Supreme Court to hear your case. So that is them saying, we would like you to come argue your case. That's the writ of certiorari. To be granted the writ of certiorari, you need to pass what's called the Rule of Four. The Rule of Four states that for the writ of certiorari to be granted, 4 of the 9 Supreme Court justices have to want to hear the case. They have to think it's important enough. And again, they're only going to be listening to cases that have supreme constitutional importance. So things that need to be settled, questions that were brought up by previous rulings, major issues, things like that. They're not going to hear every single case that's brought up to them. In fact, it's some ungodly low number. I forget the exact percentage, but something like 5%. I'm sure someone can look it up if you really want to know the exact percentage, but pretty bad in terms of like the odds of you getting a case. Because so many cases are brought up to the Supreme Court, the actual Supreme Court justices don't honestly read them all. Instead, they depend heavily upon the law clerks. The law clerks are, for lack of a better explanation, basically interns who work for each of the justices. Their job is to help write the decisions, but also to read all of the cases that are brought up to them. So they read them and then recommend the Supreme Court to the Supreme Court justices whether or not they should hear the case. They say, either I think this is a good idea or it's a bad idea. To make their job even easier, the law clerks have combined their work into a gigantic, what they call cert pool. The cert pool is all of the cases that are brought before the court, and then the clerks just divide it evenly amongst themselves and share their reports with each other, cutting down on the workload they have to do. So what that means is, despite the veneer and this image of the Supreme Court as all these justices sitting around and poring over law books and deciding the fate of individuals, honestly, your fate is pretty much in the hands of the interns, which is kind of depressing, but, hey, it's a bureaucracy. It is what it is. So once 4 of the justices agree that it's a good idea to hear the case, it moves on to the actual arguments and so forth. Now, before you show up at the Supreme Court with your argument, this is going into deciding cases for the record, the first thing you file is your legal brief. Your legal brief is your written document that explains your side of the case, all of your supporting evidence. These can be as long as you would like. It's all the supporting evidence you have, because there's no time limit here, whereas there is a time limit when you do oral arguments. In addition to your legal briefs, though, you're also going to get amicus curiae briefs. Amicus curiae roughly translates as friend of the court. Amicus curiae briefs are filed by people who are not in the case, but who would be affected by the case. So, for example, if it's a case involving, say, the media, every single major media organization is going to file an amicus curiae brief. So let's say, Disney's being sued. Every single media company is going to get in there. Warner Brothers, Fox, Universal, everybody's going to file an amicus curiae brief because anything that affects one of them would affect all of them. The purpose of the amicus curiae brief is sort of threefold. One is to point out things they might not have thought about, like say, have you thought about this angle? The second thing is basically to try and point out the number of people who'd be affected by this decision. Sort of their way of saying, hey, look at us, this is a big thing. And the third thing, honestly, is to drown them in paperwork. The idea is that by putting out so many briefs, the justices aren't going to read them all, but they're going to look at the 10,000 pages of paper and go, wow, a lot of people seem to be on that guy's side. 10,000 people can't be wrong. It's, the whole 10 million Elvis fans idea. Ask Ms. Burek for further explanation if you really want to understand that reference. But in any case, the idea is that by putting out so many amicus curiae briefs, you're trying to overwhelm the court into deciding in your favor. Again, it's like writing a 50-page essay in the hopes that I don't read it, and I just go, you know what, that's an A for effort. That's somewhat of the idea of the amicus curiae briefs. So, after the briefs have all been filed, then you go into the oral arguments. Each side gets 30 minutes to argue before the Supreme Court. So a total of 60 minutes is all you get before the Supreme Court. Again, each side gets 30 minutes. The petitioner goes up and talks for 30 minutes. Then the petitioner goes up for 30 minutes. God, I'm having a brain fart right now. The respondent is the other one. God, my brain's not having a happy time right now. So the petitioner goes up for 30 minutes, then the respondent goes up for 30 minutes. The purpose of the oral arguments is not to actually argue your case, because you've done that in your legal brief. Instead, the purpose of the oral argument is simply to answer questions that the justices might have. So the justices can say, look, I read on page 78 of your brief, you said da-da-da-da-da. Now, did you mean this? Or ba-ba-da-ba-da-da-da. So it's their chance to argue with the lawyer, to understand what they're trying to get at, to point at flaws, and it's a chance for the lawyer to highlight specific information. But again, the bulk of the information comes from the legal brief, not the oral argument. So, they've read your legal brief, they've heard your oral argument, and now they, have to decide the case. Now, there are several factors the justices take into account when they go into, making a decision. Internal factors refer to things that are going on in the justice's head that might cause them to decide one way or the other. The first thing being their philosophy. Their personal philosophy is slightly different from ideology. The philosophy of judicial activism is the idea that you believe you can overturn previous rulings that were mistakes. Whereas judicial restraint means you are bound by previous rulings, no matter how flawed you think they may be. So a judicial activist would be someone who says, you know what, that ruling was bad, let's make a new one. Judicial restraint, on the other hand, says, look, this is what we've already decided, I don't like it, but it's what the law says. Generally speaking, judicial activism is a more liberal philosophy, judicial restraint is a more conservative philosophy, but it's not quite that simple. It doesn't always overlap that way. So, for example, Brown versus Board of Education, by definition, is a judicial activist decision because it overturns previous decisions. Likewise, another good example would be like John Roberts. John Roberts is a very conservative justice and so forth. When he voted to keep Obamacare, it's not because he personally likes it. He's a Republican, he's a conservative, but he's a big believer in judicial restraint. He's saying, look, this is what the law says. I don't like it, but I can't break that. So it is constitutional, even though I don't personally like the idea. So just because their ideology is one thing doesn't necessarily mean that their philosophy is going to match that, and they're going to necessarily be able to follow that. Another thing that they have to consider with their internal things is their backgrounds. Every justice comes to the table with their own personal experiences, their own personal prejudices, their own personal knowledge, and so forth, so that does affect things. So, for example, you might find in cases involving, say, gender in the workplace, that the female justices come to it with a different set of attitudes and questions than, say, the male justices. Likewise, cases about, say, minorities might go differently for a white justice than a minority justice. So everyone's got their own background and so forth. Likewise, again, loyalty is a factor, something that justices do take into account. They do try to remember what side of the bread their butter is on. And so while, again, they're not responsive to the president or to Congress or to the political parties, there is a sense of, I'm here for a purpose. Sometimes if it's a tiebreaker, if it's a tie on all angles, loyalty can be the deciding factor. So those are all internal things that are going on in the justice's head. You also got external factors like public opinion. Again, justices aren't elected, so they don't have to worry about getting voted out of office, but they are human. So they care what people think about them. They care about what people say about them. They care about what the media says about them. They read the internet, I'm sure, on occasion. And so as a result, public opinion can sway them. Public opinion can force them. For example, again with the Obamacare ruling, one of the feelings was that Justice Roberts was sort of caught between a rock and a hard place, that no matter what the public said either way, he was going to get a lot of flack for this. So he was sort of stuck in a position. So he kind of went with the one that he thought had the more legal basis for it, which again is judicial restraint in that case. Likewise, the gay marriage case, there were a lot of feelings that the justices were like, you know what, the tide has turned on this one. Other times they will buck public opinion. Again, when Brown versus Board of Education was decided, over half the country still thought segregation was a good idea. So public opinion isn't always taken into consideration, but it can be. Another thing, court politics. The idea of court politics is that sometimes it's the personalities of the justices themselves. Sometimes, like, a justice will be so coarse or rude that they'll pick the other side of it just because they don't want to be on his side. Or sometimes a justice will be so persuasive they'll work together. Like, for example, Justice Thomas and Justice Scalia frequently vote together. I think they voted together something like 90% of the time. And so the feeling generally is, the two of them just trust each other. And so as a result, if one is leaning this way, the other one will probably lean that way as well. And finally, you go federal wishes. What does the government want them to do? While the government, again, can't force the Supreme Court to do anything, they can make their wishes known. And again, the Supreme Court probably will take that into consideration. They won't necessarily, again, agree with it and always do what the federal branch wants, but they will probably think about it. Finally, results. So what are the outcomes of a Supreme Court case? So everyone gets together, the justices talk about it, and then the justices vote. These are the possible outcomes. There's reverse. Reverse means that the previous ruling was wrong. This is the new ruling. So reverse means we're overturning what happened, what the previous ruling said. Here's a new one. Remand means we're sending it back to the previous court for a new trial. Reverse and remand are usually associated with each other because basically what they're saying is the previous trial was bad, do another one. The previous ruling was bad, do it again. So reverse and remand are usually tied together. They don't always have to be tied together, but they usually are. Affirm, as you might guess by default, affirm is the previous ruling was correct, nothing needs to change. So reverse is the old ruling was wrong, remand is go back and do it again, and affirm is the previous ruling was correct, nothing more needs to be done. In addition to these rulings, because those are really short, you also have the opinions. The opinions are what the justices write that explain how they came to their conclusion, why they feel the way that they feel. The majority opinion is written by the majority, by the winning side, if you will. So if it's a 5-4 decision, the 5 justices write the majority opinion. The majority opinion is the important one because it's the one that basically creates the constitutional law. In it, there's the explanation, it's all the famous quotes, it's how this case should be read, it's how this case should be used. Sometimes there are limiting instructions in there, like they'll say, we only mean for this to mean this and never this. Sometimes it's very broad, but the majority opinion is the one that's really, really important. On the other hand, you've got the concurring opinion. Concurring opinions are written by justices who agree with the majority, but want to point out something in particular. Like they might point out, something that they thought was particularly significant or they thought was particularly relevant. And finally, you've got dissenting opinions. Dissenting opinions are written by the losers. So in a 5-4 decision, the 4. The dissenting opinion does not carry much weight in terms of law, but it can lay the groundwork for a future case down the line. So somebody might point to, say, the dissenting opinion in Plessy versus Ferguson as the rationale for the majority opinion in Brown versus Board of Education. So while the dissenting opinion at the time doesn't mean much of anything, in the future it can be something incredibly valuable. Okay, that was a long one, but that takes us through the Supreme Court. And finally then, lesson 6, so you're going to prison.